Welcome back, everyone, to Immigration and Jobs Talk Show. This is Nipasa Pradhan, and I'm very happy to be here once again today and excited for this episode as well. So, I just wanted to say thank you so much for joining us. We are streaming live right now on YouTube, LinkedIn, Facebook, and Twitter. And before we start off with today's topic with our guest today, I have this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, thank you so much for joining us. And let me tell you that this is going to be a very interactive session, and you can participate in it as well. All you have to do is comment wherever you're watching, YouTube, LinkedIn, Facebook, Twitter, that's where. And you can, if you have questions regarding your status or want to know about what's going to happen, feel free to drop them in the comments. We'll be very happy to take them up with our guest for today. So, I think without further ado, please help me welcome today's guest, none other than attorney Chand Parvathaneni, all the way from Dallas, Texas. Really great to have you back again, Chand. Thank you so much for joining us.
Thank you, Nipasa. It's nice to be back.
Yes, and folks, you can see today is going to be the second episode on this topic because it was a very interactive last session as well. I had a great time chatting with you. What are the challenges in transitioning from F-1 to H-1B? So we had a lot of questions, and it was really nice. So Chand, maybe if you could summarize quickly of what we discussed last week, and before we start off today's session, it would be very nice.
Sure. So last week we talked about what's a F1 student visa and what's a H-1B, which is a work visa. And we kind of talked about how people move from F1 to H1 in general. We talked about the overview of the process. And more importantly, we talked about the compliance. Because lately we've been seeing a lot of, people getting involved with some criminal offenses. And last week when we went live, we just had an issue in Dallas area where a bunch of Indian students, they were arrested for solicitation of prostitution. And then a few weeks before that, we had some issue where we saw some students and their employers, they were involved in a human trafficking case where the employers were exploiting these students. So we saw some issues, and we've been hearing about people getting into brushes with the law, getting arrested for DUI, driving under influence, driving while intoxicated. And we also had some issues where students were getting arrested while they were doing some kinds of shoplifting. So we are seeing a lot of issues pop up where some students are not following the rules and getting arrested. So we talked a lot about compliance and the need to be aware of the rules, uh, and be very, very cautious in making sure that you are 100% complying with all the rules and regulations, and ensuring that you never do anything that could get you involved in any kind of a criminal act where you could possibly be arrested, because the rules are very strict. Even if it's a $5 item, if it gets stolen from, say, Walmart, people are going to get arrested. And they have such good uh, sophisticated mechanism of detecting shoplifting, so people will get caught. And if somebody is driving while intoxicated, they're going to get caught, because we see so many times when people think that they will not get caught, and they get caught, and then they come to us. So I think last week's call was more about the need for compliance, how people are getting arrested, what would happen if somebody gets arrested while they're on F1, how it would jeopardize their whole immigration career, how sometimes people could even get deported, and majority of the times the visa will get cancelled. So all those issues. So today, I think what we will do is we will dig more into the transition from F1 to H1, because if somebody is in US from India trying to get a very good solid education, that's why they're on F1, which is a student visa. With an American education, more than likely, it's kind of a guaranteed thing that people will have a very good career once they graduate and come into the work life, and which is what I think everybody should do:
Mhm.
successfully complete your degrees, finish the terms of your F1, and then transition into a good career, which is what I think everybody wants to do. So we'll talk more about how people transition into their careers after their student visa is over, and the challenges that people face, and all kinds of issues surrounding that transition, student life to a work life.
Absolutely. I am excited about today's session because I'm sure folks out there are as well. Plus, the new fiscal year is coming up very, very soon. I'm sure, people are thinking how can they shape or in which direction to go ahead from here on. So I'm sure Chand will be able to guide us today with all our questions. And to break the ice, I have a few questions myself, Chand. So the first question I have is, if someone is currently employed under post OPD status, do they need to stop working while applying for their H-1B visa, or can they continue working throughout the process? And additionally, is applying for an H-1B visa during post OPT the same as requesting a change of status, or are they, completely separate procedures?
So, if someone is employed under post OPT status and they're applying for a H-1B, so depending on the circumstances, they can still continue to work. And the first thing that normally people will see is if they have a valid EAD card, the OPT EAD card, whether it is the initial OPT or the STEM OPT. And if their
Okay.
EAD card is valid, typically there is never a problem. And a lot of times what happens is once the H-1B is filed, a lot of people says OPT card expires. Say the filing is being done in April, because April is when the filing can start, and then the EAD card, the employment authorization document, expires. There is this feature called cap gap extension. And what this process is if an individual on an OPT, if they're selected in the H-1B lottery, not only selected in the lottery, but their employer also files a H-1B petition before this OPT expires, then they have this feature called cap gap, where they can go to the school, their university, ask for a cap gap extension I-20, and then still legally continue to work on their OPT uh, status even after their OPT expires. And they can continue to keep doing this until October 1st. So this is a very good feature where OPT expires, but somebody can still work because their H-1B is pending. And this is something what a lot of people, a lot of students use, because their OPT cards, a lot of them do have a problem where their cards are expiring after their H-1B is filed and the H-1B is still in process. So that's one very good feature for people whose EAD card expires. And then talking about change of status versus counselor process. So normally, if somebody is in US, they are in F-1 status, they are on OPT. And what typically happens is they want to convert from OPT to H-1. They don't want to continue their OPT, even if it's valid. So the default thing that normally happens, or most of the people, most of the students, what they request is they want a change of status. Even if their OPT is still valid for a long time, they typically opt for change of status. And what this means is once their H-1B is approved, it is valid from October 1st. Even if their OPT is still valid after that date, the OPT expires, the EAD card expires, they convert to H-1B. So that is what is typically going to happen with most of the folks. But USCIS gives a choice. They can choose to go through counselor processing. And what that means is people who have a valid EAD card, they can uh, they can elect to stay back on F1 status, continue working on their OPT status, and they can still get an H-1B approval. So this is called counsel processing. And what that means is the H-1B approval is not really valid until they go out of the country, get stamping, and come back. Only then their H-1B status activates. But until then, the approval is valid. It is just that they have to continue on a legal status in US if they're in US. And since we're talking about students, what that typically means is they have a valid EAD card, they continue to work on OPT, and irrespective of their H-1B getting approved, they stay back on F-1 status. And that is through consular processing. So the key things to look for is look at when your EAD card expires. Is your EAD card expiring after the H-1B is filed? And how long your EAD card is active. So based on that, a lot of people either opt for change of status or consular processing. And for the folks out there who don't have a valid EAD card, they just opt for cap gap extension.
Okay. Okay, thank you so much, Chan, for taking that up, and very interesting. I'm sure friends out there have questions. I can already see some of them commenting. So, quickly, hi, Kaushik. Thank you so much for your questions. We will take them up, but just stay with us for now. I have another question, Chand. What essential information should both employers and employees be aware of, while a student on an F1 visa is transitioning to an H-1B visa, especially considering the October 1st start date?
Sure. So when the fresh H-1B is filed for anybody, so there
Hmm.
is this start date, and October 1st is the earliest start date that they can request. So when you talk about these CAP filings, always October 1st is a very, very famous date. The reason is that is the earliest time that they can convert to H-1B. Even if the filing is done right after the lottery in April,
Hmm.
so the H-1B, even if it's filed in April, the start date can only be October. So October 1st is a pretty standard date. And so the main things that the company should look for is the cap gap, because most of the students that are probably already working for that company, and this cap gap is important because if not for cap gap, a lot of students whose EADs are expiring, they will have to stop working. They will have a gap. So
Okay.
all these companies who have filed for their students, they have to look at cap gap and see if any of their employees fall into
Hmm.
the cap gap. And those guys, they just have to make sure they use cap gap. And cap gap is only valid until September 30th. So after September 30th, for some reason, if the H-1B is still not approved, it is very important that the employers stop employment or pause the employment and wait until the H-1B is approved. Or normally the better option at that point of time is upgrade your cases, because you do need to get an approval by October 1st. If not, the cap gap is only until September 30th. So after September 30th, a lot of folks whose EAD card has expired, they might not be able to use cap gap. They can stay in the country, they cannot work. So that's a very important thing that a lot of employers will have to look for. Ensure that there is no interruption in the work status. And then a lot of employers, they also have to worry about the filing timelines. So the timelines in general are March is when we have a lottery. April, May,
Hmm.
June is when the first set of applications can go out, the first lottery. And then the deadline is June 30th. So since we are past June, we are expecting that the majority of employers have adhered to the filing deadline. If people have
Hmm.
not met the filing deadline, those cases are gone. And then we had a second lottery. We had a second lottery in July, last weeks of July. So now, again, there is a deadline. So again, we have 90 days. And for anybody that is selected in the second lottery, we have time until November. So they should probably be looking at the deadline for those cases that got selected in the second lottery.
Okay.
Another important thing that every employer has to make sure is look at the H-1B approval. If it is a change of status, you will have an I-94. If it is council processing, you will not have an I-94. So the employers, they have to make sure if they have an I-94 or not. If they do not have an I-94, they cannot employ somebody on the basis of the H-1B approval. So all the
Hmm.
employers and even the students out here, you should be looking at your approval copies. Make sure you take a look and see if you have an I-94, because if you have an I-94, it means you have a change of status approval. If you do not have an I-94, it means it is a counselor approval. So you do have to maintain your F-1 status. You do have to ensure that your EAD card is active. And you do have to go back to your school and make sure your service is not terminated. Because sometimes, even for counselor processing cases, the service gets terminated. So you have to go back to your school, request a data fix, and get that fixed. So that is something that students also have to ensure. And the final thing that employers and the students who are converting to H1 should consider is the travel consideration. So before October 1st, before your H1B is approved, if you have any travel considerations, do talk to your company, do talk to the attorney who has filed your case. If you're requesting change of status, there are strict rules against travel. So that is something what you definitely have to consider if you have any kind of a travel plan before October 1st. And then the final thing for the employers is maintaining compliance. So employers do have to update their I-9s, because a lot of them are getting approvals. So I-9 compliance is very, very important. And there are strict timelines for I-9 compliance. So every employer should be looking at I-9s. And I-9 is something that every employer has to have their employees do. So even if it's an employer hiring a US citizen, a green card holder, H-1B, F-1 OPT student, it doesn't matter. Everybody has a burden of doing an I-9. And because for the lottery cases, because the approval starts from October 1st, and a lot of people will get an approval on H-1B from October 1st. So a lot of these
Mhm.
employers, they must be looking at their I-9s, updating their I-9s. And overall, I think the big thing is compliance. So I think every employer out there who is applying for a H-1B, they have to know the H-1B regulations. They don't have a
Mhm.
choice. They have to pay on time. They can't bench anybody. So these are all these rules that everybody has to follow.
So keep in mind, friends, and thank you so much, Chand, for giving those tips. I'm sure people are going to keep them in mind, and I hope you took notes, friends. At this moment, I also would like to say hi to Sunita Joshi. Thank you so much for your comments and your questions. We will take them up. Shaukat, hi. And then we have Peterson. Let's take Peterson's question. He's saying, I have H-1B visa, but wondering about the visa interview. Who can help? Any
Sure.
tips maybe for
So
his visa interview?
Sure. So when you go for a visa interview, there are two things that you have to prove. One, you have to prove your credentials that you are qualified, and the other
Mhm.
thing you have to prove is you have to prove that you have a legitimate job assignment. So you can only go to US if you have a valid assignment. If you're going to go and sit on the bench and the company is going to find you a job, it is
Mhm.
not legally allowed. So what you can do is the first the people that would help you is your employer. So your employer, what they do is they give you the H-1B approval copy. They also have
Mhm.
to give you a recent employment verification letter, and it's a basically a letter basically that states you have an assignment, and when you come to US, this is what you would do, and this is what you would get paid. That verification letter is very important. And on top of that, what they should give you is they have to disclose the LCA copy to you. The LCA is mandatory. The LCA copy has to be given to you because that is how you know where exactly are you going to work and what is your job title, what is your salary, and so on. So normally, what we suggest is we suggest the employers to give the entire copy of the petition that was filed with USCIS to you. So that way,
Mhm.
you can see your role, your job duties, what kind of an assignment, what kind of a project, what kind of a client assignment, if any, is assigned to you. And then the employer should at least give you a brief idea about what your role is, okay, and what your assignment is. Maybe like a brief summary of your assignment. If it's a client assignment, this is your client, this is your assignment. If it's an
Mhm.
in-house project, this is your work, this is what you would do. So the goal is you need to get help from your company to get an idea of what assignment is being assigned to you once you come to US. Where are you working? What is your title? What is your salary? And so on. And normally, every company that I work with, they typically what they do is at the time of stamping, they try to give the entire copy of the H-1B petition to you that has all these
Mhm.
documents and give a recent verification letter. That kind of gives you an idea what exactly are you going to do because you do have to know which company you're working, where you're working, and so on.
Mhm.
And end of the day, if the visa officer is satisfied that you are qualified, and the way they see it is your work experience, your educational qualifications, and so on, and they definitely run background checks on the employer in US. They see everything is right, and they're convinced that you have a valid assignment. You typically get a project. If they are not convinced, normally what happens is sometimes they're not convinced. Sometimes even if they're convinced, they want to do some additional background checks. So what they do is they issue a 221G, and there are
Mhm.
different kinds of 221Gs. Sometimes they give you these are the documents we require from you. So sometimes they give you upfront, and sometimes it is more of doing some kind of a background check, doing some PIMS check or some kind of a check on their side. So
Mhm.
depending on it, they give you a 221G, but most of the time, the 221G, once the background checks are cleared, it gets cleared. Okay. So bottom line, do work with your employer, do ensure that you get a copy of your H-1B petition, do get a copy of your verification letter, and then attend the interview.
Okay. Peterson, all the best for the interview. And I hope that was very helpful. Thank you, Chand, for taking that up. All right. So, also, Peter, if you have more questions, you can always contact Attorney Chand. His details are scrolling down on the screen. Moving on now, Chand, I have another question. And if you could tell us, how does the Federal Insurance Contributions Act or the apply to individuals transitioning from F-1 visa to an H-1 visa, H-1B visa, and who is responsible for paying these taxes?
Sure. So FICA taxes, it's very important, and every employee in US typically, the employee has to pay, employer has to pay. So
Yes.
the FICA tax is basically the Federal Insurance Contribution Act. It's called FICA in short,
FICA,
And
yes.
FICA is composed of two things: so social security taxes and Medicare taxes. And this FICA taxes that we're talking about, it helps the government pay for social security, pay for Medicare once people retire. And the rule is every employee in US has to pay FICA, and it is close to around 7.5, 7.6%. And whatever the employee pays, the employer also has to match. They have to do a matching contribution. Employer also pays. So this goes to this FICA contributions. And the rule is everybody pays, every employee pays. However, there is an exception for F1 students. The reason is F1 students are treated as non-resident aliens. The H-1B employees on the other side are treated as resident aliens. So for tax purposes, a H-1B person or a US citizen or a green card holder, they're all treated the same. They're resident aliens for the purpose of tax. The
Mhm.
students on the other side, they're not treated as resident aliens. They're treated as non-resident aliens. And
Okay.
what that means is when you're on F1 and you got an OPT card, because you got an OPT card, employment authorization, you start working. So when you start working, you technically become an employee of a company. But even if you're an employee of a company, you are given an exemption from FICA taxes under certain circumstances, uh, because you're treated as a non-resident alien. And what that means is you do not have to pay that 7.6% approximate FICA contribution from your payroll. Employer also
Okay.
does not have to pay that from their side. And this is for F1. And when you do a transition from F1 to H1, the minute
Which one?
you get onto H1B status, you are a resident alien, which means you have to start contributing to FICA. Your employer also
Mhm.
has to start contributing to FICA. And in this context, the transitioning from F1 to H1B, this is very important because a lot of times what happens is the students, they're already working for that employer, and the
Mhm.
employer is already paying them. And since the payroll is already being run, they forget to change once the status converts to H1B. So on October 1st, when a lot of the
Mhm.
folks out here, they convert their status to H1B, employer forgets the FICA part because they just assume that since they're paying them, they're just going to pay them the same way. But it is very
Mhm.
important that once you're on H1B, the FICA taxes are very important. They have to be paid. So anybody that is converting to H1B, it's a good time. Talk to your employer and make sure that they don't accidentally forget it. Okay, so this FICA thing is very important. You don't do it, you don't pay it typically when you're on F1, especially if you're in the country less than 5 years. Once you
Mhm.
convert to H1B, almost always you have to pay FICA. So your employer, most of the time they do catch it. Sometimes they forget about it. Very important. Talk to your employer. You have to start paying FICA taxes once you're on H1B.
Okay, friends. So it's very important not to forget about this, especially when you're transitioning from your F1 visa to your H1B visa. And thank you, Chand. Well, Chand, you were talking about the tax. Is there like a certain percentage or a certain amount? Is it like fixed or, variable person to person?
So it is. Yeah, so it is fixed. So typically it is 7.65% of the gross wages. And it has two
Okay.
components. One, it is 6.2% for Social Security. So Social Security
Mm-hmm.
is basically once somebody retires after 65 years. So what happens is the Social Security fund, it pays for people after their retirement. And that's why
Mm-hmm.
they charge 6.2% from the employee's paycheck. And even the employer also has to do a matching grant. So 6.2 is Social Security. And then there's something called Medicare. So Medicare is basically the medical health insurance that people get after retirement. So there is a 1.45% for Medicare. So theoretically, when you add them up, it is 7.65%. And this is out of the gross wages. And together it is called FICA tax, federal insurance contributions. And employee has to pay 7.65%. Employer also has to pay 7.65% from their side. So
Mm-hmm.
together you're looking at more than 15% being paid out of the paycheck every month towards FICA taxes.
Okay. There you go, friends. I hope that's very clear about FICA. And thank you so much, Chand, for taking that up. At this moment, I think I would like to take this question from RK on YouTube. So RK is asking, if your parent is a US citizen and want to file an I-130 for you, the person is under 21 but married, are they still immediate relatives, and what will happen to the spouse, to that spouse?
Uh, So if your parent is a US citizen, uh, so theoretically you are an immediate relative, but you come under the quota. So because you're married, you come under a different quota. I don't
Mhm.
do a lot of family-based immigrations, but again, you have F1, F2, F3, and F4. There are four categories. F4 is for siblings, and F2 is for spouses of green card holders, and F1 and
Mhm.
F3, these are for the children of US citizens. One is for unmarried, one is for married. So you'll have to fall under one of those categories. I am not really sure with this question. Because normally when you're married, you're above 21. It's a different rule. So when you're under 21 and you're married, I'm not really sure how it works, and I'll probably have to look
Okay.
upon that, and I can get back to you on that by next week.
All right. So, Rick, I think we will save your question for sure. But thank you for asking. And if you got your answer, it's well and good. But otherwise, you can always keep commenting, write your questions, and we'll try to take them up. But we will remember this, Chand. We will get back. Chand will get back to us again with this in the coming week. All right. Thank you, Chand. Thank you, Rick, as well, for your question. And now I think we should take up another one. This is from Kaushik on YouTube, asking, I am on an F-1 visa and I just got my I-765 work permission. I have three questions. I am currently a student employee. I only work 2 hours a week. Can I work 40 hours per week now? And the second question is, can I
So,
apply to any job outside of campus? Okay, let's go one by one. Let's go with this
mhm.
first.
So if somebody is on F1 visa and they don't have a 765, 765 is basically when they apply for EAD card. So when somebody just enrolls in a school and so basically they're studying in school, they do not have a EAD card, or they do not have a approved I-765, which is application for employment authorization. At that point of time, they're supposed to work only a max of 20 hours a week, part-time employment, and that employment has to be on campus. That is for any student in general. Out of campus work is not allowed during student status, unless they're eligible for OPT or they get work authorization either through CPT. So in this case, since 765 has been mentioned, so my guess is they have applied for OPT and they got an approval. So once the 765 is approved, at that point of time, they are allowed to work off campus. They're allowed to work for more than 20 hours a week. So they are free. The only criteria, however, is the job has to be in the field relevant to their course of study. So if somebody is studying computer science, so they can do jobs relevant to the IT industry, computer industry. They cannot go and work in a hotel. So the bottom line is, yes, you can work off campus. You can work 40 hours a week because now you have I-765 approved. But if it is through OPT, there is a very, very important requirement that that work outside campus has to be in the line of your study. So you can't just work in any industry. The job duties that you're performing has to be relevant to your course of study. So as long as you're able to show the nexus between your course of study and your job assignment, you should be able to work off campus, and definitely you can work for 40 hours a week once your 765 is approved.
Great, great. And thank you so much, Chand, for taking that up. Kaushik, we will definitely get to your second and third question, but quickly regarding the previous question from Rick, we have an update for you, Rick, and that is you do not fall under F1 category anymore as immediate relatives because you are married. So that is the case. Thank you so much. Thank you so much, Chand. And now let's take up Kaushik's second question. Can I apply to any job outside of campus? He's asking.
Um, so again, I mean, again, when you say 765, I'm guessing it is because of your OPT, because of your OPT
Mhm.
that you applied for 765. But some people apply for 765 because they become eligible through some other ways. For example, if somebody marries a US citizen for some reason, they
Okay.
also apply 765. But in your case, I'm assuming that your 765 was because of the OPT. So because of your OPT, if you have applied for 765, you got an approval. So what needs to happen is you do need to inform your school when you're working in any job. So normally what you do is you have to note, there is a requirement to notify your school DSO. Your school
Mhm.
DSO will update the service, so your service is updated with all these changes. So normally what you
Okay.
do is, yes, you can work off campus, You do have to go through your school DSO, make sure your service is updated. So anytime you move to a new place or you move to a new employer, just let your school DSO
Mhm.
know, and the school DSO will update the service, and you're good to uh, work for 40 hours. And the question where I say is, you said that you think you will graduate before you get your green card.
Before a green card,
So
yes.
when you're a student, unless there is some kind of a green card application, you'll not get a green card. So I think limiting the question to F1 status, the 765 to F1, you are good to work. Just inform your school DSO. Make sure your service is updated at all times, because notification to the school is very important. Service getting updated is very important. So you do have reporting requirements. So make sure
Mhm.
you're ensuring that you're complying with the reporting requirements.
All right. Thank you so much for taking that up, Chand. And Kaushik, thank you for your question as well. I hope that was very helpful and pretty detailed explanation, Chand. Very nice to have you here. Friends, you can always contact Attorney Chand Parvathaneni directly. He's based out of Dallas, Texas, and you can definitely go check him out. He is from SPB Law Firm, Sim Parvathaneni and Brown Law Firm, and they are based out of Dallas, Texas. You can call him on the number 817-523-8247, and definitely mail him at law@spblawfirm.com. Once again, law@spblawfirm.com. Thank you so much. And Chand, we will take a short break now. We'll definitely get back because I have many questions, and so do our folks. And we still have another half of this session coming up for you, friends. So don't go anywhere. Stay tuned to Immigration and Jobs Talk Show with me, Nipasa Pradhan. Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408 335 6444 or mail us at nipa@higherightpeople.com or visit our website www.higherightpeople.com. Welcome back, everyone, to Immigration and Jobs Talk Show. And this is the second half of the session we're having today with none other than our guest for today, Attorney Chand Parvathaneni, based out of Dallas, Texas. And today we're talking about what are the challenges in transitioning from F1 to H1B. It's the second episode today. We have been discussing about this, and last week as well, we had a very, very interesting webinar. So I would suggest, friends, that you go check that out as well on our channel. And if you haven't already subscribed to us, don't forget to hit that like button, the subscribe button as well, and hit the bell icon so that, whenever we have discussions like these, you are definitely notified and can join us immediately. All right. So, Chand, thank you once again. It's been interesting so far. We're hopping in and out of audience questions and my questions. So, covering F1 to H1B. Well, I have more questions. I think we'll take them up quickly. My next question
Hmm?
to you is, if an individual returns to their home country shortly after entering the United States on an F1B visa and later decides to return to the United States, could this cause issues as the port of entry or at the port of entry or during the re-entry process?
So anytime anybody has traveled and they're coming back into the country,
Mhm.
every time they have to go through a CBP inspection. So the return is not guaranteed. So people can have a visa, a H-1B visa, but the return is never guaranteed. So every time they have to go through a CBP inspection, and each time they get back into the country, they really have to convince the CBP officer that they have a genuine assignment and the company they're working for is a legitimate company. So that requirement is always there. And normally, what the CBP officers do is they have some pointers. So and they also have some red flags. And so based on that, some people have more scrutiny, some people have normal scrutiny. And if somebody comes to US and goes back to their home country, all of I mean very very quickly, again, that by itself is not a problem because people can have some legitimate reasons. Maybe they came here and they had some issues. Maybe they have a family back home, so they had to go back, or maybe they could not
Mhm.
adjust here properly, so they had to go back. So I do see a lot of times where people come here and they get all their initial work done, maybe get their SSN, start their work,
Mhm.
but then they realize that they're not ready yet, and they go back. And it's kind of understandable because coming to US, it's a big geographical change, it's a big environmental change. So uh, people might have some legitimate reasons, so they do go back. And normally, again, the question is, I think we can frame this into two ways. One, they quickly go back to their home country right after coming to US, and then some people come to US immediately, and some people wait in India for extended time or wait abroad for extended time. So maybe 1 year they're back, and then they're trying to come back. So at the time of coming back, definitely the CBP officers are also going to look at the approval dates on the H-1B and what kind of a break they have taken. So if they've gone back to their home country, did they stay back for a long time, or did they stay back for a very short time? So based on that, sometimes they can frame questions differently. But in general, what I have seen so far is they can ask a lot of questions, but as long as the employee is able to convince on the day of return back that they have a genuine assignment, they're going to work for a genuine company, they're going to adhere to the terms of their LCA, because the LCA is very important. They have to comply with the LCA. So if they're able to show to the officer that their intention is to work as per the terms of the H-1B approval once they come into the country, the visits don't matter. They can ask a few questions, and as long as people have some legitimate answer, the issue is more about when they enter, do they have a valid assignment or not? And if that is true, uh, even if the stay abroad is for a short time or for an extended time, I normally did not see a major issue. But again, people can expect scrutiny if the travel does look a little bit odd. But again, it does not mean anything because different people have different legitimate reasons of travel. But do ensure when you're coming back, always get an employment verification letter from your company, because we had some cases where people were sent back, and
Mhm.
the reason they were given is you do not have any communication with your employer. Because I had a case where they said it has been 4 months, you're out of the country, and there is no communication with your employer. Your employer does not even know that you're coming. And they said, do you have any proof that your employer knows? And this person was not able to show any proofs, either in the email or anyway. So they said, we don't think that your employer even has an assignment for you because you don't have any communication with your employer, and you're coming back into the country after a couple of months. We don't think you have enough work. And he was deported back. We had actually seen two cases in the last couple of months where
Okay.
somebody were deported back, and the reason they got was you're not in contact with your employer, so we don't believe that your employer even has an offer for you because they're not even expecting you. Okay, so
Okay.
I think what we suggest is, before coming back, get a latest verification letter from your employer confirming that they still have an assignment, and kind of giving details about your assignment. Okay, because you do get questioned at the CBP on
Mhm.
your role, and they do want to see some evidence. Okay, because you can say something, but they need to see evidence, and that letter from the employer is a good evidence to show that
Mhm.
once you come back into the country, yes, you do have work available. You're not going to sit on the bench, or just like try to find a new employer and move to a new employer.
Right, right. So the employer verification is very important, especially when you are traveling out and you're planning to get back to the US. I mean, so that you're not questioned too much at the port of entry or during the re-entry process. Thank you, Chand, for taking that up. And also at this moment, I think I'll quickly say hi to Nisha. Thank you for your question. And also Mahesh, stay with us, please. We will take them up. But now, Chand, I also have another question. And if you could tell us, is it possible for an individual on an H-1B visa to change employers, and what are the legal implications and requirements for doing so?
Um, so there are some visa categories where it is like you cannot change your employers, and the best example is L1 visa, for example. L1 is used by a lot of Indians, a lot of highly qualified people all around the world, and L1 is one of those visa categories where changing employers on L1 is not very easy. It is, I mean, you cannot just like change to a different employer on L1. So it is a restrictive visa. On the other hand, H1B is very, very flexible. And that is like one of the strengths of H1B visa, and which is why H1B is so popular.
Mm-hmm.
And I mean, even when the H1B visa was designed, it was designed in such a way to attract talent from all over the world. And when you want to attract talent, you want to give the employees the flexibility to move to a different employer if they have a better career over there. So that way, we have a dynamic environment where people are able to move to better careers. And that way, you're actually attracting talent, because if somebody is locked to an employer, they're not really interested to come to US. So H1B visa inherently uh, supports porting of employers. And what that means is you can change employers very, very, very easily. So today, if you find a new employer, in about 10 days, you can start working for a new employer. The new employer does not even have to get an approval. The minute the new employer files a H1B petition, even if it is pending, you can go and start working for the new employer. So the bottom line is H1B is a very flexible visa. It is a good visa to move in your career. As you get a better offer, you can always move to a better company. And that being said, when you're talking about F1 to H1B transition, there are a few caveats. So F1 people, say in April, your company filed a H1B. In May or June or July, say your company got an approval. You cannot transfer right away. The reason is the cap H1Bs, they're only valid from October 1st. So before October 1st, if somebody tries to do a transfer, it could get rejected. Only after October 1st, because you get onto H1B status typically on October 1st. After that, once you're on H1B, H1B to H1B transfer is very easy. But before October 1st, especially for the cap H1Bs, the H1B does not even start, does not even kick in until October 1st. And before October 1st, for some reason, if your employer decides to withdraw or revoke the H1B, tomorrow you'll not be cap exempt, and you'll not be given that flexibility to find a new employer. So,
Mm-hmm.
so once you're on H1B, you definitely have that flexibility. But before you get on H1B, because H1B the first time starts from October 1st. So before October 1st, typically you won't have that flexibility. But the minute you're on H1B, changing from one employer to another employer is very, very seamless and a straightforward process. And you see people doing it all the time, because in IT world, especially, the market is very good in general, and you have a lot of opportunities. There are a lot of tech companies. So what that means is you are allowed to change employers. If you get a better career, go for it.
Great. Thank you so much, Chand. And thank you once again, friends, for your questions. I will take them up. But Chand, if you could also explain, how the F1 higher cost 3 can assist international students in unlocking US work permits and how it relates to the H-1B visa process. Before this question, if you could just tell us about F1 higher cost 3, what is it really, would be nice.
I mean, I've seen this course. I think it's a course by some private parties where they help educate students who are in US about various work opportunities. I think it gives some kind of feedback, some kind of overview, some kind of uh, uh, information on what kind of opportunities people have. Because when somebody is on F1 visa, they have work opportunities on OPT status, they have work opportunities on CPT, and they also have work opportunities after on H1B, and so on. So this is more, I think it's a private program where they talk about various options people have. They try to educate students and try to prepare them for a work career, so the transition from F1 studies to a job. It's kind of some kind of a transition program where people are educated, and it kind of helps the students get that awareness. Because one of the things is, a lot of times people don't know what kind of opportunities they have to progress in their career. And these kind of courses, what they do is they bring that awareness amongst students, and they kind of give lay out the options to students, because a lot of times we see people, they make a mistake because they don't want to follow the rules, they want to comply with the rules, but sometimes they don't educate themselves properly, and in not doing so sometimes they mess it up, and they messed up their immigration status. So that's why I think courses like this are good opportunities where people find out what kind of options they have, and kind of be prepared, get ready when the time comes.
All right, all right. Thank you so much for that, Chand. And also, I think now it's time to take up some questions from our audience. They have been waiting for some time. So let's take Sunita. I was in US on F-1 plus H-1B for past 12 years, but recently I lost my job. Now I am in Canada where I have my legal status, but my H-1B status is discontinued. I want to take some time off, say 6 to 12 months, to upskill myself. After this, can I apply for US H-1B jobs and move to US again? I do have approved I-140 filed in 2020. What will be the challenges if I want to move back to the US on H-1B?
Yeah, good question. So looks like Sunita was on H-1B status in the past. That is very important, and not only that, she also has an I-140, and
Yes.
that is awesome. The reason is, if you have an I-140 and you have a H-1B in the past, if you find a new employer, they can file an H-1B for you immediately. They don't have to wait and go through the lottery system. They don't have to. They don't have to wait. So the
Okay.
beauty is, once you have a I-140 approved, so I-140 is basically the immigrant petition filed by the employer. So if you have an I-140 and you had H-1B sometime in the past, it doesn't
Mhm.
matter, 10 years, 15 years. But because you had an I-140 in the past that is approved, you had a H-1B in the past that is approved, if you find
Mhm.
an employer, immediately they can sponsor a H-1B, and you'll be able to come to US and start working. So for the other folks out there, they have to wait until the lottery. They have to pray and hope that they're selected in the lottery, and only then the company can file for a H-1B.
Gotcha. Mhm.
And because you have that flexibility, and not only that, because you're near shore, you're in Canada, you might be able to interact with employers, and once you find a good employer, they can immediately start H-1B. They can do it in premium, and probably in less than a month you can come to US, start working on H-1B. That is like the best option. The other thing is, I think Sunita also mentioned that she's in legal status in Canada, but at
Yes.
some point of time, if you are able to get Canadian citizenship, there is another visa called TN. The TN visa is a very powerful work visa. A lot of people who immigrate to Canada get Canadian citizenship, the Canadian passport. They use
Mhm.
TN visa to come and work in United States. So if you're in Canada and at some point of time you're getting Canadian citizenship, or if you're close, TN is also another visa that you can explore. But if not, H-1B is something that you can explore right away.
Lovely. I think Sunita's case is totally untangled and many options for you, Sunita. So I think a very good status you have, and you have many options. So I'm sure you'll be able to figure out what would be best for you. All the best. Thank you for your questions, by the way. And now let's take up Mahesh's questions on YouTube. I am on H-1B and got laid off, and my wife is on H-4. I am looking for day one CPT as an option for my wife from H-4 to F-1. If I don't get a job within 60 days, does she need to leave the country to move on F-1 from H-4? And my second question is, can I move from H-1B to H-4 dependent on her staying here in USA?
Sure. So looks like Mahesh just lost his job. So what you have to do is mark your 60 day. So mark the day when you hit the 60th day from your termination date. So for example, if you're laid off, say on July 15th, you probably have up to probably August 15th, September 15th, probably. So just calculate your 60 days and find the exact day that will be your 60th day after you lost your job. And before this day, if your spouse who's on H-4, she files a change of status application from H-4 to F-1, she can
Mhm.
stay back in the country, because you have 60 days. You have 60 days. your wife also has 60 days if she wants to change her status. So within the 60 day, before the 60 days are up, if your spouse files for a F1, change of status from H4 to F1, then she does not have to leave the country. She can stay back in the country and she can convert to F1. So that is number one. And number two, if she converts to F1, simultaneously, you can also do H1B to the dependent, which is F2, not F4, F2. So you can
Okay.
convert your status to F2 from H1B if your spouse is going to be on F1. So definitely you can do that. And your wife does not have to leave the country. The only key thing to remember here is you got to get this process done before 60 days.
60
And what that
days.
means is in your spouse's case, it is not just applying for F1. She also has to get admission in college. So she has to get that admission. She also has to get the I-20, and you also have to pay
Mhm,
the service fee. The service receipt fee is very important. So once
mhm,
only
mhm,
you do all these things, only then you can do the F1 application. Okay. So I would say at least you probably need a couple of days to ensure that you do have admission in the school, you do have all these things ready to file
mhm.
the F1. So don't really wait until the 60th day, because there is the school admission process that has to be done. So try to
Yes.
be proactive. Ask your wife to be proactive and start working with schools. And as long as you get things done before 60th day, you and her, you can stay back in the country. Once you cross 60 days and you have not made any filings, then pretty much you'll be out of status. You would have to
Mhm.
depart the country.
Hmm. So, Mahesh, time is ticking. I do hope that you still have your 60 days. It's still counting. And I hope that you make it, all the best. And yes, time is ticking. So, quickly get it all done. Go check on the school admission and everything. And all the best. I hope you figure out. Thank you, Chand, for taking that up also for Mahesh. Now, let's take up Nisha's question. I am planning to get my H-1B stamp and need some advice. I filed out the DS-160 form and selected the New Delhi location. Also, I chose New Delhi as the post for my visa application. I was granted an interview waiver, but I've been struggling to book an appointment for over a month. It always shows no slots available. However, today I noticed that there are some slots open in at the Chennai VAC, and I booked an appointment there. I'm wondering, is it okay to submit my documents at Chennai VAC, or do I need to reschedule the appointment?
Yeah, since you've been able to get an appointment at Chennai, you should be able to submit your documents to Chennai. So go ahead at your time, and they should be able to help you out.
All right, Nisha, all the best, and don't you worry, it's going to work out. Let's take up Mohit's question now. I'm currently on an F1 visa working on OPT, and my employer has agreed to sponsor me for an H-1B visa. However, my OPT expires on October 15th, and my employer's H-1B petition won't be filed until April 1st for the upcoming fiscal year. What are my options to maintain my work authorization and status between October 15th and the potential H1B approval, considering I'm eligible for the cap gap extension, but my employer is hesitant to file the H-1B petition before the deadline.
Um, So I'm not sure if you mean that your work status, your EAD card is valid until October 15th. Because if your EAD card is valid only until this October 15th and your employer is filing the H-1B next year in the next year's lottery, then you will not be eligible for cap gap because your OPT is expiring this year in October. So I'm not sure if you framed your question right, but assuming that your EAD card expires this year, and if your employer does not file your H-1B before your EAD card expires, you will not be
Mhm,
eligible for cap gap. One of the very important requirements for cap gap is that before your EAD card expires, look at the date on your EAD card. Before that expiration of that date, your employer has to file for a H-1B. And if you're talking about next year, there is no guarantee that you'll even get selected in the lottery, because I think you're talking about next year, and next year for the employer to even file the H-1B, you have to go through the lottery. You have to get
mhm,
selected in the lottery. So next year, again, there is no guarantee that about the lottery and what will happen in the lottery and so on. But normally, what you might have to do is if your OPT is expiring in October this year, and you want to stay back in the country, you have to ensure that you have a legal way of staying back in the country. And in your case, what that means is you have to maintain your F1 status. And if you want to study, what that you do have to get admission and you have to continue your F1 program. Or if not, you have to depart out of the country, because the minute your OPT expires, you have 60-day grace period. And if your H1 is not filed, you do have to depart out of the country. Or if you want to stay in the country, then at least you have to continue your F1 program. So what that means is you have to start working with the school, get admission and get enrolled in a program, and start making sure that you attend classes and maintain all the terms of F1. So bottom line, if your H1B is not getting filed before your OPT expires, look at ensuring that you get admission. And if that is your interest, if you want to do an F1 program, you have to make sure that you do it. Otherwise, there is a 60-day grace period, and if you don't depart the country in 60 days, your service will get terminated and then you'll be out of status. Okay, so make sure you do understand about that 60-day grace period once your OPT expires,
Mhm.
or your H1B has to be filed before your OPT expires.
Very important things to keep in mind, Mohit. And thank you for your question. I hope you got your answers. Thank you, Chand. Well, I have a question, Chand. What are some of the most significant challenges that individuals face when transitioning from F1 visa to H-1B visa, since that is our topic, and how can they navigate these challenges effectively? If you can just quickly give
Yeah.
a few pointers, since we've
Yeah.
been discussing since the last webinar we had.
Yeah. I think one of the biggest challenges I've been seeing this year and also last year is they have an employer. The employer files for the H-1B because they're on F-1 visa. They're probably working for them. And then before the H-1B petition gets approved, because you're seeing a lot of layoffs happen in the country, uh, there are some employers who terminate employment before the H-1B starts. I've seen cases where before the H-1B got approved, they went through a layoff. I also had cases. I mean, like the prime example that I saw last year was a bunch of layoffs in Amazon. These students had approvals from Amazon, but before October 1st, Amazon laid off a lot of people, and these students, uh, their H-1Bs were revoked. I consulted with a couple of the students, and they didn't have a choice, because even though their H1B was approved, but that H1B was revoked before October 1st. So they had an approval, they got selected in the lottery, but the big challenge is sometimes the market conditions, sometimes the company they're working in. If they revoke the H1B before the H1B starts, they have a big problem. And what that means is they also not only lost the H1B, now they have to go back to their school, make sure their service is not deactivated. For some people, because the H1B got approved, the service was getting deactivated. So they had to
Okay.
go back, they had to make sure the H1B was withdrawn properly. And they talk to the school DSO, make sure the school DSO knows that the H1B was revoked. So they are
Mhm.
reinstated back in F1 status and all those things. So that's a big challenge that I see when they're transitioning from F1 to H1B after they get selected in the lottery. But
Mhm.
again, the next most significant challenge is even getting selected in the lottery. I have seen people,
Yes.
because the H1B lottery is so competitive, and so many people are applying in the lottery. I mean, a couple of years back, we have seen this huge problem of multiple registration. This multiple registration was a mess. Multiple companies were applying. They acted like they're not related, because they're indeed not related. But on the back, what was happening was they were colluding, because they're claiming that they had a bona fide job, but they did not have a bona fide job. So because of multiple registrations, we did see a lot of people lose out because they're not getting selected in the lottery. And this year, there was no multiple registration nuisance, because USCIS took care of that problem. But still,
Yes.
we still had the lottery oversubscribed by a couple of multiples. And what that means is that H1B lottery, going through the lottery, is a big, big, big unknown factor. And we see some people do two masters. I've seen one person do three masters. So he was trying to stay back in the country, and the only way he can stay back in the country is maintaining legal status.
Mhm.
And he was going back to school, making sure he was following all the rules of F1. But it adds up. I mean, you're staying in school for such a long time, you're paying a lot in tuition. So the lottery is a big significant hurdle to pretty much every F1B student,
Yes.
every
It,
F1 student. trying to get converted to H-1B, that because we only have 85,000 H-1Bs and the demand is too high. I mean, the demand is outstripping the number of H1s that are available out there.
So true.
So the big thing is, I mean, again, all the students can do is find a legitimate employer. We also saw a lot of shady employers. They,
Hmm.
especially with the multiple registration issues. So people just
Yes.
believe their employers, and then they realize that even though got selected in the lottery, their H-1B is getting denied. Or even if it is approved, USCIS detects fraud, they come back because USCIS will revoke a H-1B if they find fraud. And the way they
Hmm.
find fraud is even 1, 2 years down the line. Sometimes they detect fraud, they go back and revoke the H1s. So
Okay.
finding a very good employer is very important. I mean, do not downplay that part. Every employer is not the same. Your employer has to be a legitimate employer. So just because you have a H1B employer, somebody filed a H1B, you got an approval, uh, that is not enough. The H1B has to be a
Mhm.
legitimate employer. Tomorrow you go to them, they have to start paying you. They cannot put you on bench and not pay you. So these things are also very important. Students, because sometimes they are naive, they believe any employer. Just because the company is registered in US does not mean the company is legitimate. And if a company is just recently registered, it does not mean the company is not a genuine
Mhm.
company. It can be anyways. So do some research. And it's a significant challenge not finding the right employer. That is probably the biggest challenge, working with the right employer, a genuine employer.
Mhm.
So be aware that there are some employers out there who act like they're legitimate, but then USCIS goes back and detects all these fraudulent findings against them. So overall, get a good employer, make sure the employer puts you in the lottery in a legitimate way, and try hope for the best, because at the end of the day there is still this lottery. So you are left to the chance. I mean, you are left to your luck at the end of the day.
Mhm.
There are only certain H1Bs that can be given, but at least one thing that's in your hand is finding the right employer, finding a genuine employer. So don't go and accept any employment with any employer, but only with legitimate employers.
So true, so true. And you talking about fraudulent activities, Chand, you gave. Can you actually tell us some of the most common fraudulent activities with regard to H-1B visa process, and how can these applicants, protect themselves from falling victim to these schemes, apart from doing research, that is? And before you get
Yeah,
to the answer to that, I would just
yeah.
say quickly, Feza, I've got your question. I'm going to take up right after this question, so please stay with us. All right? Yes, Chand.
Yeah, yeah, I would say in the H1B process, especially from students, because students are so naive when they're getting into the H1B process. The first fraudulent, uh, I mean, the thing that you should be looking for is if some employer asks you to pay money for the H1B, it is fraud
Mhm.
written all over the place. H1B employer cannot charge you money for H1B. Okay, so any
Okay.
company that is trying to take money from you and file a H1B, that's the biggest thing, that's the biggest sign. So I want all of you to be cautious about anybody charging money for H1B. Very important. That's the biggest fraudulent activity that at least I see in my practice, because sometimes people come to us for consultation and they say this employer is
Mhm.
charging them money, or all these things. Okay, so employer charging you money for H1B, it's rampant, and you refuse to pay. And there are ways. We actually did a session a couple of weeks back about fraud and how to report fraud. Okay, so it was a session that we did, and it was, I think, something that everybody should understand. There are good ways of reporting fraud. So if you see fraud, somebody's charging you money, somebody's not, that is very important. Report that fraud. Another thing
Mhm.
is trafficking. So sometimes you're forced to work, you're not paid. So if somebody is forcing you to work, they're not paying you. By H1B regulations, you cannot be benched. They have to pay you. Employer has to pay you. Again, there are various ways you can report issues. You can report it to DOL, you can report it to USCIS. So another thing everybody should understand is you cannot be put on the bench and not be paid. The regulations require the employers to pay you no matter what. Even if you're on the bench, they're supposed to pay you. So that's another thing
Okay.
that everybody should be aware of, and uh, be cautious. And the other thing is, uh, I mean, again, so those are the, I think, the main things that I see from a H1B visa process. So don't fall victims of these things. And then there are other things where, in general, you want to be a little bit more aware of your surroundings, because sometimes people try to come up with
Mhm.
all these schemes out there. They send you emails. They say we are a USCS officer doing a site visit, Or I mean, sometimes they are genuine, sometimes they are fraudulent. Because we had cases where somebody were called and said, "Don't get off the call. You have to pay us, otherwise we will come and arrest you." So we had seen some operations like that where somebody was on the phone and people were pressurized to pay. So you have seen those kind of fraudulent activities also. But these are like general things that everybody should be aware of. From a H-1B
Mhm.
perspective, I think I want to be more focused on the employer, your job, and anything that is not correct over those areas. Just remember that there are various ways you can report these kind of things, and make sure that everybody is following the rules. Employer is following the rules, you're following the rules. And don't collude with your employer and say, yes, this is okay, let's do it this way. Don't I mean, within even the legal framework you can do a lot of things. So I think whatever you do, you should do it within the legal framework. Within the legal framework,
Yes.
there is a lot of leeway that you have. Follow that. Don't misrepresent things, and try to work with somebody that is committing fraud.
So true, Chan. Thank you so much for, enlightening us again, once again, with all these fraudulent activities and the various ways we can report. And for detailed information, friends, do check out our previous episodes with Chand, because we have discussed this earlier as well on immigration and jobs talk show. Now it's time for Faisal's question. I promised we will take that. So Faisal is asking, I am on F-1. My master is still continuing. I got my H-1B approval from October 1st onwards. My service will expire by 25th September, as I will not be enrolling in next semester. Will it affect my status?
So in general, once your F1B program, once your F1 program ends, you have 60-day grace period. So within 60 days, you're supposed to depart the country. And in your case, in 5 days, from October 1st, you have H1B approval. So you are falling within the grace period. And starting October 1st, your status automatically converts to H1B. So you are in valid status. So you are good. You should not have any issue at all.
Great. Faisal, there's nothing to worry. You are safe. So what's route of green card from H-1B from Pakistan? Okay, all the way from Pakistan, Faisal is asking.
Yeah.
It's
So the good news is, yeah. So the good news is, if you're from Pakistan, your green card will be a lot more faster than for somebody who's from India or China. The reason
Mhm.
is Pakistan falls under rest of the world category, and rest of the world category, the dates are very, I mean, almost close to current. If you look at EB2, it is in 2023, so it is almost close to current. And we work with a lot of people from Pakistan. We help because we are filing a lot of green cards for some of our clients who were born
Mhm.
in Pakistan. And
Okay.
Pakistan, the dates are very good, okay, because your green card is based on country of birth for employment based. But you have to go through the similar process that anybody from any other country would do. And what that means is, you have to have a legitimate employer. Employer will have to file an I-140, and once I-140 is done, you do the I-485 filing. So that process is all the same, but where
Mhm.
you get that advantage is, you come under the rest of the world. So the rest of the world, the dates are very, very favorable. So because your dates are so ahead compared to India, you pretty much are allowed to apply well ahead of time compared to somebody from India. So the process is still the same. It is just that it is a lot quicker, a lot faster, because you're born in Pakistan.
There you go, Faisal. Well, the details are scrolling on the screen. Definitely contact Attorney Chand Parvathaneni. Call him on the number 817-523-8247, and you can mail him at law@spblawfirm.com, and definitely go visit spblawfirm.com to get to know more about Chand and the law firm SPB. Thank you, Faisal, for your question, and I think that would be the last for today, if that's fine. And thank you so much, Chand. I hope you had a good time. There were some more questions, but I think we will take them up in the next time. And yes, thank you. I had a great time, and we had a detailed discussion, two episodes, two webinars on this topic. So, Chand, what do you have to say to wrap up this topic finally?
Sure. And a lot of the F1 students, they also got selected in the second lottery. So whoever is selected in the second lottery, make sure you're working with your employers. The deadline is coming very, very close. So anybody that has got a selection in your in the second lottery, make sure the filing is done timely. And anybody who has already got their filing done in the first lottery before June 30th, make sure you're working with your employer, make sure you know the status, And starting from October 1st, if you already got an approval, make sure you're complying with H-1B regulations from October 1st. Things like FICA that Nipasa was talking about earlier. Make sure you check into that FICA from October 1st. Make sure you're transitioning properly onto H-1B from October 1st, and work with your employer. Okay. So, and the big thing is from October 1st, if anybody who's got an approval for H-1B, you have to get paid as per the LCA. So a lot of the salaries for a lot of folks would be different because now you have to adhere to the LCA wage. So make sure you look at
Mhm.
the LCA. A lot of the wages for a lot of you folks might be different from October 1st, because October 1st, H-1B regulations will kick into effect if you got an H-1B approval. And
Yes.
that also means that you have to be paid as per the LCA. So just look at your LCA, make sure everybody has a copy of your LCA if your H-1B filing has been done, and make sure you get paid as per the terms of LCA from October 1st, which is the first day for a lot of people who got an approval in the first lottery.
Great. Thank you so much, Chand, for wrapping up our episode today and this discussion on what are the challenges in transitioning from F1 to H1B. And it was great having all these questions from folks out there who are so participative. I loved all the questions and how you quickly, so sportingly took them all up and answered in detail. Thank you so much, Chand, for doing this today as well.
Thank you, Nipasa.
You have a great day, Chand, and I hope we can all catch up with you again in the coming week.
Sure, sure.
Thank you, Chand, and thank you, friends. Thank you for joining. Thank you for your questions, and don't forget to like, subscribe, and share our content. And to subscribe, hit the bell icon also, so that you'll always be notified when we have discussions like these. Also, remember that we also sponsor H-1B visas, H-4s, and you can contact me with anything with regard to immigration and jobs. You can write to me. You can call me on my number. You can even WhatsApp me on this very same number. My number is 408-335-6444, and my email address is nipa@higheritpeople.com. And to get to know more about us, go check us out at www.higheritpeople.com. Now, this is it. Y'all out there have a wonderful day ahead, and stay tuned to our channel because we have a lot more on immigration and jobs. Only on Immigration and Jobs Talk Show. This is Nipasa Pradhan signing off for now.
Are you an IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com or visit our website www.higher